of the executive, the head of the legislature, is to ensure that none of them will begin to harass the other with power. Is to ensure that that separation of power...
Which is what is going on now.
Which is what is going on now.
Which looks like what is going on
now. Yes, it is. And this does not augur well for any country. And it has just ignited some more things that will follow. You see, I expect, maybe on Monday now, I expect the CJN's lawyers to go to court and nullify that other ex parte. You see, it's also immoral, very immoral, for that tribunal to make such an order. You adjourn a matter on the 22nd, then the following day, you said you are now making an ex parte order. That is, that order was made in the absence of the other parties. And I've gone through this order. It's another made suo motu. Order made suo motu, that it means that it was done without any person prompting the court to do it. Why did I say so? On the face of the order, every ex parte order that I've known, I'm approaching 30 years at the bar now. Every ex parte order will state that after listening to counsel for the applicant, the court hereby make this order. In this particular order, there is no mention that the court listened to any lawyer requesting him to make that order. That means the order was made by the court, by the tribunal itself, a day after he has already adjourned the matter to determine whether he has jurisdiction or not. So there is a lot of immorality in this. And for a president of the country also to proceed to say he was acting on the order of the tribunal when the order did not even say so, is a higher immorality. So,
but Shukwa, you lawyers, I mean, your forte is just to confuse Nigerians.
We are not confusing. You see, the rule of law, like the president said, is a technicality. The CJN was in technicality. The rule of law is technical. It's only those who are trained, those who know it. Lay persons should not think that they know. They can just come. No, they cannot. It's like I'm not a medical person. I cannot go and begin to talk about medicine. But everybody now suddenly wants to become lawyers. No. So it is technical. The same technicality was used to bring the president to power. The same technicality in law was used. Otherwise, he will not be where he is. He is now. It was good when he benefited. Now, when others are not benefiting, it is no longer good.
No, Shukwa, what I'm saying is that, okay, like you said, everybody is now trying to be a lawyer.
Yeah.
It's only lawyers who can interpret this thing for us.
Yes.
But we are getting different interpretations from all of you.
Yes.
So we're all just sitting down and throwing up our arms, totally exasperated.
You see, that's
because we don't know what to believe we don't know who is right and who is wrong anymore.
You see, what I will ask you to believe is look at the sequence of events as it happens. As a lay person. There was a proceeding on the 22nd. The court itself agreed that, yes, I must first determine whether I have jurisdiction or not. Then on the 23rd, he said he made an
without even determining
whether they have jurisdiction or not. The matter is adjourned to 28th. That's on Monday. So what is the urgency?
Before Monday.
Before then, what is the urgency? Has anybody died, or is anybody about to die, to lose his life before the date of adjournment?
Okay, you have said that everyone is trying to be a lawyer,
yes,
dissecting what the issues are. But have you heard also that people are saying, you've mentioned these technicalities, that the CJN, its lawyers, just trying to use these same technicalities to ensure that nothing is done.
You see, they are already in court. If they wanted to ensure that nothing is done, they will not even come to court. Now they are in court, they have submitted to the court, they are already engaging the court. That yes, but you have no jurisdiction because certain things that are thought to be done before you can charge him has not been done. And now because, okay, let me listen to you, I will listen to you on the 28th. Then before that date, it's not technicality, we are talking of law here. Law is technical to those who don't know it. But to those who know it, it is not technical. We are very clear. We can determine the end from the beginning, based on what the law says, based on decisions and the precedents of the court of law, and we have no problem with that. If you have different divergent arguments from lawyers, it is normal in our profession to look at things from different perspectives. That's why you must hear from lawyer to the first party and lawyer to the other party before the court will take a decision. But what that tribunal has done is not to listen to the two parties. Even though the court itself, the court has said, I want to listen to the two of you on the 28th on this issue before I can exercise my power. But without waiting. I think that what that tribunal chairman did was a great injury.
So if you say it's injury to justice, why do you think this will be so?
I think it was so because he himself is under pressure.
Who is the
I
he
think
now?
So. The tribunal chairman is facing his own charge. He has been charged to court by EFCC, and he is facing that trial, and the president did not deem it fit to tell him to step aside. And meanwhile, that tribunal is under the executive arm of government. So it is like the same executive arm is the one pursuing a matter, is the judge in that matter, is the one executing the matter. At the same time, I mean, any Part 1 lawyer, a Part 1 student of law, we know that, no, you don't be a judge in your own matter. You should allow the two parties to converse before you, then you take a decision. Right now, there's no decision on jurisdiction. And those who bring it's not technical. It is normal. So be sure that you don't waste our time and the time of everybody. Do you have jurisdiction over this charge? The bureau has raised an issue. The Code of Conduct Bureau is different from Code of Conduct Tribunal. The bureau, they have investigated. They have brought a charge before you. And the lawyers to the person is saying, no, the bureau cannot bring that charge. It's only when they can properly bring that charge that you can exercise your jurisdiction over it. When you say, okay, I will listen to you on the 28th, then on the 23rd. Look, something is fishy.
Some have said that there is an ulterior motive to all of this, and it has to do with the elections.
Yes, it is becoming...
What are your thoughts?
Actually, I've tried not to follow that train of thought because I try not to be political when we're talking about what the law says. The legislature that promulgated these laws, they did not write politics into it. But when it comes to execution of the law, then political considerations come in. Yes, election is coming in February, and if you feel you are not comfortable, no, why will a contestant begin to feel from now that I'm not comfortable with the head of the judiciary?
Those are speculations.
Yes, they are speculations.
You are saying we should stay with the law.
And you know that today, Saturday, the man was supposed to inaugurate the panels. They are already listed.
Yes.
And meanwhile, the Chief Justice of Nigeria doesn't act alone. He acts together with other justices of the Supreme Court. They have arrived at a list which he was going to inaugurate today. But it's as if they are not comfortable with that list. That means they have their own personal preference. So if that is the politics of it, then there is trouble.
Quickly before we go, let me read what Festus Akinboyewa is saying here. He said, PMB is only trying to bring sanity to a confused situation. Majority of our lawyers thrive on technicalities. It's amazing how the lawyers have ignored the substance.
Now, substance is different from what we are talking about now. Substance of the case to the layman is that, yeah, I suspect you of stealing. So the lay person will expect that person suspected that somebody should just put tire on his neck and ignite it and then burn the person to death. You know, that is injustice. And that is what is happening now. Before that allegation is substantiated, you are now punishing. No, that's not. The substance is not substance until it is well thoroughly examined and then the decision is proved in court.
Okay.
Nigerians should not just believe whatever allegation is made. If anybody makes an allegation, don't believe it. They said the man has already written that yes, he has written. That writing in itself is a defense for him in law. Okay. That means he has complied in law. So,
interesting days ahead.
Mr. Olashokwo Ojo, Executive Director, Center for the Rule of Law. Thank you very much for coming to shed more light on this for us this morning.
I think there's a difference between morality and legality. The people should not confuse it. Morality, don't bring moral arguments to, unless the judiciary, unless the legislature writes morality in that law, then it becomes a consideration.
Thank you very much for coming. Sunrise will return with another interesting conversation in just a moment.